It's 29 minutes to 11 o'clock. This is ENCA. Thanks for joining us. We are this morning focusing and zooming in on the implications and significance of the High Court ruling in Pretoria yesterday regarding the lockdown regulations that government imposed under Level 3 and Level 4, which the judge has found to be unconstitutional, unlawful and invalid. I'm joined by Ntabiseng Dubazana from Dubazana Attorneys, Dr. Justin Ramegis from TGR Attorneys, and constitutional law expert from the UCT, Professor Michael Osborne. He is on the line. The other two guests are on us via Skype. Can I just ask the following question now? We've explored a number of the others. I just want to know, what are the prospects of success for government should Cabinet, after studying this judgment, make a decision to appeal it? What chances are there that government may succeed in applying for leave to appeal at this stage, instead of taking opportunity or using the 14-day window to respond to this? Can I start with you, Justin?
Thank you so much. So what we have to see is they obviously have to do a constitutional consideration of the rationality of the provisions that have been set down by the state, by the judge in the applicable judgment. And should they appeal it, they obviously have to put up a better case. What we've seen is, and the difficulty in matters of this nature is that the application was brought on an urgent basis. We see from the judgment itself that there's been some difficulty with the minister being able to produce the correct evidence on that basis and to support its position. What we can't discount is that from the inception of the lockdown regulations, there's been broad consultations with different stakeholders, the scientific community, in order to set out what this regulation should be and how it will restrain persons in its in their daily lives. And so, while some of those provisions surely seem on the face of it to be irrational, it would be the state who has to prove it based on facts and evidence. And matters brought on an urgent basis, ordinarily, they dispense with ordinary timing proceedings and documentation. So it might have a better opportunity at an appeal level, and plus it will have two more bites of the apple, or three more bites of the apple potentially, until confirmed by the Constitutional Court.
Ntabiseng, your view?
I agree with Justin. The state has a very big opportunity in appealing, and therefore, because of the judgment that is currently handed out, not only did the judge say it's giving it 14 days, but the judge also said that in as much time as the court may deem it fit to give the minister time to amend the regulations. So if they request more time as well, if they choose not to do the appeal route and they request more time to amend the regulations as per what the court has instructed, perhaps this time bring in legal minds. They'll be able to guide them and assist them, and as to how to make sure that the regulations do not step on the toes of the people, and especially the toes of the Constitutional Court in this regard, or the constitutional rights in the Bill of Rights in this regard. So perhaps maybe trying to amend would be the best way, but on appeal they have lots of ground. They have a lot of ample time to put their cards in order and make sure that when it goes on an appeal, they can get what it is that they feel they need or they deserve.
Prof. Osborne, do you share the same sentiment as Justin and Ntabiseng?
Yes, I do think I share precisely the same sentiment. This is a matter that I don't think anyone would disagree deserves the attention of the Constitutional Court. It would probably be one of the most important decisions in the Constitutional Court's history. There's enormous gravity and urgency, and it's something that affects almost every constitutional right that one finds on the book. So, yes, there will surely be an appeal, and if I had to guess, I would think that there's a good chance that some aspects of the appeal might succeed, if only because, and I think Justin mentioned this earlier, the whole High Court procedure was done on an urgent basis. There's not clearly sufficient time for the minister to fully articulate the government's defense. You can be sure that on appeal, we'll see a much, much more extensive articulation of the government's reasoning, and some of those defenses then might succeed, and all or part of yesterday's judgment may be set aside.
Yeah, and I think it's important just to point out to our viewers, as we're having this discussion, that the court was very clear that during this period of suspension, this next 14 days, no matter what happens, the regulations that have currently been published under alert level 3 shall apply. So nothing changes. We're still under lockdown level 3 while this legal issue is being tackled. I think that's a very important point to mention. And the judge also saying that despite the shortcomings, some structure still needs to remain in place whilst the minister and the national executive, so it's a collective, review the regulations and their constitutional approach thereto. If you were advising government currently, Ntabi Singh, what would you tell them was the best course of action? Go to appeal or review, amend, and publish a new set of regulations that respect the Bill of Rights?
I would go for the latter. I would advise that let's see if we can review and republish the ones according to what will be, entrenched within the Bill of Rights. Because I believe taking the constitutional route, although it is going to be very important, like Professor has said, it will be one of the biggest constitutional related cases in our history thus far. Although that will be a profitable one to say that they were right in that respect, I believe that right now in the current situation that we are at, the best way is to try and make regulations that will help us deal with this unprecedented situation with COVID-19 and make sure that we are going in accordance not only with the law, but also with the health of the people. That way we're saving enough time in order for us to deal with the situation or our situation with COVID-19 as it develops. Because remember, these regulations are not things that were done in the past and therefore we're putting them into action now. These regulations are being dealt with as the situation changes in our country. So we need to make sure that we are up to date with the changes, and that will also help the people navigate themselves in a way that will also help the law to not help the government not to step on the toes of the law. I believe that right now the best way is to let's go back to the drawing board and let's redraft and make sure that we're doing things right in order for us to continue making new regulations as we go into level 2 and level 1. And now we'll know what to do when we go to those other levels, because we're now aligning ourselves with the requirements and the requests of the Constitution.
Or it could be beyond COVID-19, Justin. I want to hear your view there, because the judge said that the declaration of a national state of national disaster for COVID-19 was rational, using the Disaster Management Act. But he points out in part of his ruling that the National Disaster Management Act in and of itself is not really taking into account situations of a COVID-19 type pandemic. He even uses the example of the recent floods we had in the country to say that under a flood situation, when you have a disaster, the Disaster Management Act applies nicely, but not for COVID-19 situations. Surely going to the Constitutional Court could help us with the future, because we don't know whether or not we'll have a similar type of pandemics in the future or even worse.
I think the last time we faced a pandemic of this nature was in 1912 when we had the Spanish flu. Obviously, there wasn't this broad mass media and the ability of government to communicate en masse with the population at the time on how to regulate a particular pandemic. I think where is government needs to take a stock-taking exercise. Each of these regulations were informed by certain submissions, one would think, from the broader stakeholders, from scientists, in order to collate them and populate them and release them into the public. And the idea, as I understand it from the regulations, the purpose was to prevent or suppress the curve, equip the state appropriately to deal with the pandemic. And there was never a position where we were not living with this pandemic. I think it was to appropriately prepare the state to deal with this specific nature. So whether the state should amend the regulations as is, because the order was to test the rationality. It should look at what is available, test those provisions, and if it feels that they are constitutional in nature, they should appeal. But on the face of the documents, it's difficult to tell because we don't have the information which informed the introduction of that piece of regulation, and that's a very important piece. So I think the stock-taking exercise will give government sufficient understanding of if there is a necessity to amend the regulations, and if there is not, they should take a different route. But if there is, then they should amend accordingly.
And Prof, what is your view? I mean, should it go to the Concord to try and give some clarity for a future perspective, or should they just adopt a short, medium-term approach, review, amend, and republish a new set of regulations?
I would guess that government is going to move on two tracks. Firstly, that they will appeal to the Constitutional Court because there really is a need for guidance from the Apex Court on these complicated and very important matters. Simultaneously, on the second track, there will no doubt be amendments to the regulations. And just to note that, in a sense, these regulations are a moving target anyway. With or without this decision of yesterday, there would have been ongoing amendments to the regulations. It's possible that by the time the 14 days are up, we'll be on level 2 anyway. And in essence, yesterday's judgments will have been taken over or overtaken by events. So it's a confused situation that's moving very fluidly, and no one quite has a handle on the legal consequences when as I say, the target is moving. It may be that in 2 weeks' time, new regulations will have been issued, or will be on a new stage anyway, stage 2 or even stage 1, where this decision of yesterday will become of historical significance only.
Okay, Prof, just to assist our viewers, just to understand at a basic level from this ruling, what example would you use that would show that in the what regulation, as an example, could be used to show that it was not complying with the Constitution, it's unconstitutional?
Well, as I recall what Judge Davis said, he mentioned the ban on hairdressing, and he spoke evocatively about the hairdresser who was unable to feed her children and stood on the side of the road and saw taxis going by, each of which was more crowded than her hairdressing salon would ever be.
Yeah, in fact, Prof, I've just got it in front of me, that's 7.3 of the ruling, and the judge says to illustrate this irrationality further is the case of hairdressers. A single mother and sole provider for a family may have been prepared to comply with all the preventative measures as proposed in the draft alert level 3 regulations, but must now watch her children go hungry while witnessing mini cab taxis pass with passengers in closer proximity to each other than they would have been in her salon. She is stripped of her rights to dignity, equality, to earn a living, and to provide for the best interest of her children. I think it's a very good, strong example to use of the judge's decision of the irrationality of some of those lockdown regulations.
Yeah, precisely. The other rather poignant example was the ban on the dealing with mortality. And he made the point that it's legitimate for up to 50 people to attend funerals, but it's not legitimate for people to come to the dying person's house to say goodbye. And, to put it colloquially, what comfort is there for the deceased if he knows lots of people can come to his funeral, or 50 people can come to the funeral, but they can't come and pay their last respects before
Prof.
actually dies.
Yeah, thanks, Prof. We need to wrap it up, but I want to give each of you, and you must be very brief, just a final say of this thing. In my view, as a layman, government is caught between a rock and a hard place. How do you balance the constitutional rights of people as well when the said constitution also includes right to life and government feels or believes it was doing its part to save lives under COVID-19? How do you respond to that? Ntabiseng, Justin and Prof, very briefly as we conclude. Ntabiseng?
Oh, should I start? Oh, okay. I believe that you're correct that the government is stuck between a rock and a hard place at this stage. We don't know, we don't know how we're going to do the balancing act between the rights of the people and also protecting the lives of the people. However, the Constitution does give guidelines as to how we should do that. And remember, Section 36 does give a right for certain rights of people to be limited if it can be justifiable and if it's rational. So it has to be a balancing act in that we should get legal minds to also advise the ministry as to how to do these regulations as we go on with stages and with the pandemic that we're dealing with.
Thank you very much, Ntabiseng Dubazana. Dr. Justin Ramages, your thoughts?
I don't think it's a one-way beating like we expect. I mean, if we use your example concerning the hairdresser and the terminally ill patient, the state can put up a case for that. I mean, if you at a hairdresser, it causes a lot of irritation to cut your hair. So there's a greater likelihood of you touching your face and your mouth and the hairdresser touching your face. With regard, the wording in the judgment with regard to the terminally ill patient was that there's a prohibition to come and visit him. But we know if someone is terminally ill, generally they're in a hospital, and generally we understand from what has been released from the media is that there are a lot of COVID patients. So there's a higher degree of risk when you enter those areas for contracting the disease, where we can't say the same as 50 other people have been locked down coming to a gathering. So I think it's going to be based on facts and evidence. It's going to be based on what the state can put up, and we're going to have a real debate on the substantive issues going forward, which is necessary in order to pad out this area so we can deal with this pandemic or future pandemics or problems, emergencies appropriately.
Thank you very much, Dr. Justin Ramages from TGR Attorneys. Final word to you, Professor Osborne.
Well, yes, the government is in a difficult place, but perhaps not in as an extremely a difficult place as it might be. We've got to remember here that the test is rationality. It's not that the court will demand that the government get it exactly right and make the regulations that are precisely appropriate. All that the Constitution and the courts can demand is that the regulations be rational in the sense that it can clearly be demonstrated that the regulations that are being put in place will in fact serve or advance the ultimate purpose of the Act. That's all that needs to be done. The problems that emerged from yesterday's judgment is not so much that the regulations are wrong. It's that whatever the regulations are, there's simply not enough before the court to determine or to demonstrate that the regulations are properly calibrated in order to achieve the undeniably legitimate objectives of the whole scheme.
Professor Osborne, thank you very much for your time, and thanks to as well once again Dr. Justin Ramages from TGR Attorneys and Ntabiseng Dubazana, an attorney from Dubazana Attorneys. Well, like most things that play themselves out in court in our country, there could be some political significance. What could those be? Joining me shortly is ENCA political editor Vuyo Mvogo to unpack some of them.